So today I will present you on another very important topic when you talk about geographical indication is what do we do when we are facing infringement. Yesterday, as it was mentioned, we focused a lot on promotion of GI, so it's valorization of it. But then when you start to promote an asset, whatever it is, GI or another type of asset, you will face people who want to benefit from the exposure the asset has to eventually infringe the right of the right holders. If you remember yesterday, I present you a log frame that I represent you today about the importance to consider the GI system as a global perspective. So as we mentioned yesterday, the goal of all actors dealing with geographical indication is ultimately to have better products recognition, a consumer confidence, which will normally materialize through sustainable valorization of the products covered under the GI. To do that, we will have, when we establish a national system on GI, to consider building proper legislation. Legal framework will be key in knowing what type of right you will have to defend yourself once you are protected in a market. Then enforcement component in a legal framework will be important. Then the second step will be to give capacity to relevant stakeholders, both at public and private sector, to implement this legislation. So at different stage for the recognition of the GI, but after for the defense of the right of the right holders of TGI in a local market. And we will see also it will have implication on the defense on foreign market as well. The control system will be very important, and I will come back on that. So once the GI is recognized nationally, you will be able to start to consider a strategy for enforcement. Before it is protected, you have basically very limited capacity to protect the name protected as a geographical indication. Then once it is registered nationally, we know that we can apply also for this kind of protection in foreign market. Then we can promote the GI more easily in relevant market, but together with the promotion will come a larger exposure to the market. Also, and it's a good point, higher valorization. So there will be temptation from people to actually use this name without complying with the legislation authorizing them to do so. So that's why it's very important to have this global perspective. What are the instruments available for you as a right holders, if you are one, to protect yourself better and to protect the right linked to the protection of the geographical indication? The first question we have to ask ourselves in a country we want to defend this right is under which legislation the GI will be protected. Traditionally, that when we talk about GI, we are referring to what we call the sui generis GI system, meaning a specific legislation protecting origin products as a geographical indication. We will see also that there is also different legal means that could be also triggered to protect origin-linked products or to protect certain aspect of the geographical indication. And I quote here a trademark system to collective and certification mark, for example, also legislation on unfair competition, and also administrative system, which can be linked, for example, to custom procedures or labeling protection. So that has to be assessed when you want to protect your right in one country, what type of legislation and legal instruments are available for you to do so. Also, very important to remember that when we are protecting a GI, what will be registered and therefore protected is the name, but associated to the use of this name will be a certain number of requirements that will have to that will have been submitted at the registration of this name. It is called the specification. You remember I mentioned that yesterday. So basically, if you want to respect the law, when you use this name, you have also to comply with this document, which is associated to the authorization to use this name, which are the specification. When we are protected, generally, I try to summarize here the key element to keep in mind. First, when we are protected as GI, what are the type of rights which will be conferred? First, when a GI is registered in accordance with the provision of a national legislation, because remember, the right is a territorial right, so you are protected in the country you are registered. Only producer handling products possessing the quality, reputation, or other characteristics specified in the register, meaning the office in the country where your GI is registered, who are carrying their activity in the geographical area specified in the register, who are complying with the GI specification, have the right to use a registered GI in the course of trade with respect to products covered by the GI, not for products not covered by the GI. This right also, it's very important to remember, it is not transferable. We'll have the capacity to administer the right and who can use amongst the association of the group of producer can use the name if complying with the provision mentioned above. But this right is not transferable. It cannot be sold to other stakeholders. It cannot be delocalized as an ownership also. That's a very particular thing for geographical indication, which is very different for trademark, for example, where when you own a trademark, you are normally free to sell this trademark to whoever want to buy it, whatever location they are, because there is not necessarily a link between the right to use a trademark and the location of the user. What is also important is the GI right holders. We saw yesterday that the right holder is collective, so it could be either a group, an association, of a structure, which is the right holder of the GI, should have the right to institute a complaint to the competent court or authority, either against any person who use the GI without authorization or against any member of the GI group itself who could infringe a GI. That's why there is normally a list of GI users that should be established and maintained by the GI right holders in order to monitor later on in terms of enforcement who has the rightful right to use the GI in the market. All operator ending the products under the GI in accordance with the specification should have the right to use the GI. How to control this right? That will be the importance of the GI control system that I mentioned in the first slide. All this information associated to the use of a GI are normally controlled at different levels. First, when you are a producer of a GI, you need to control yourself if you are complying with the specification. Then there is another level of control, which we call internal control, which is by the association to all its members, checking that all the members are also respecting the law, therefore respecting the specification. But there is not only internal controls or self-control, auto-control, that are normally required under the law. There is also the need of an independent third-party control, which could be done either by public or private body or both. It is normally each country which is going to design its own national GI control scheme, meaning who and which organization are controlling which type of products. For example, if you talk about public control body, this public control body should have in their constituents and the legislation giving them the authority to control different matters, GI as part of it. And it has to be accredited eventually by national authorities, or at least it should be competent to carry out specific control for specific products. You can imagine that the control body controlling handicraft will not be the same eventually that is controlling fishery products or agricultural products. On the other hand, if you're talking about private control, that will be done by an agency which has a certain level of international recognition and need to comply with ISO 17065. So that's a good point, because this system of control normally should be recognized internationally, not only in the country where the control is actually carried out. So this control aspect will be very important. It will be also important to differentiate two different types of infringement, what we call internal infringement and what we call external infringement. So in terms of internal infringement, in case of non-compliance by the operators with a specification, the control body that we mentioned before should take appropriate measure and sanction to correct the non-compliance of operator. So we can have different level of measure or sanction. The first one will be a remark or an advice, because operator doing the GI eventually may just make a mistake and an honest mistake. So they don't need to be sanctioned, just need to be informed that they have to correct some behaviors. Then the next step will be eventually a warning. Be careful. We have informed you once, but now it's important you correct immediately the disrespect of the specification. Then if it's not working, then we have more strengthened measure. Like the first level will be the disqualification of the operator and producer for any of its products. So they will not be able to claim in their packaging or in their communication that they are selling the GI. They can still sell, for example, coffee, but they cannot use the GI name on the packaging. Then the fourth level of sanction will be a temporary revocation of the right of the operator producer in relation to the use of a GI. And then you will have the permanent revocation. So this producer will be excluded definitely from using the GI name, because it obviously doesn't want to comply with the specification, therefore is endangering the reputation of the GI as a whole. So this internal infringement normally don't actually involve authorities. It is done by the right holders with the support of the control body to basically trying to police the members to be sure that they are behaving properly. But you may have also some other type of infringement, which are either amongst producers, but also outside the producers. For example, the non-compliance with specification, if we go to the last level of sanction we mentioned in internal infringement, we may have a consequence by law also, because if these people keep commercializing these products, they are basically commercializing a counterfeited products or unlegal products. Then we may have also some producers which are not registered as rightful users of the GI, which decide to use the GI name. In this case, they are also by law not in compliance with the law, so infringement could be also done by the authorities. What we see when we talk about external infringement, which are the one which normally require the intervention of the authorities competent for this type of infringement, we may face fake products, imitation or counterfeited products present in the market. We can face also the use or the evocation of the name of the products. Your use of specific products pattern by an infringer, or cheap or poor quality copycat sold over the internet. That's some example of infringement, external infringement GI producer may face. What are the impact of this infringement? They are very diverse, but also could be very problematic. It can lead to the negative perception of the products, which is a long-lasting effect eventually on a consumer mind. There will be a loss of revenue, market share, or export market, which will lower the profit of the genuine producer. And there will be consequences on enterprise innovation, investment activity. And of course, there will be also costs associated to the action taken to fight this infringement, some an awareness campaign, some legal action to protect the right. So that is something that needs to be considered also when we are designing the strategy of protection. I give you here some example of such kind of infringement. Here you have the example of European French GI, Pruneau d'Agen, which is prune of Agen in France. And you have here the example of usurpation. You have two types of packaging. On the right side, you have the original one, which is a rightful one. The name of the brand, the name of the GI mentioned. You see also the European national label, which is compulsory on the packaging for European GIs. On the left side, you have some design, some color, which are quite similar to the original package. The name of the GI, Pruneau d'Agen, but obviously the content is not the GI, because otherwise some other information will have to be provided. So it is a case of usurpation, for example. What could be also triggered in a market is the protection of the notoriety. Some stakeholder, not only in an area of production of the GI, may use the reputation of the GI to also apply to their products to attract the consumer. You have two cases which were quite famous. Here, it was, for example, the use of the name champagne for the production of perfume of a French brand, and also for the production of cigarettes. When you are the owner of champagne, you will not see that as a way to promote your products. So you may find yourself upset of the use of the GI name on these products, and you can find a prosecution on a court if the law of the country you filed this prosecution may support this type of operation. In France, for example, these cases were won by champagne GIs because they was recognized that it was a use of the notoriety of the champagne without any authorization or agreement of the champagne right holders. What you can have also is the fact the name may be used on different type of products that may eventually suggest there could be eventually some champagne as part of the component of these products. Here you have some example of biscuit. So when you read that as a consumer, you may be misled to think that maybe these biscuits are made with some GI. Because there is a name of the GI quite obviously advertised on the packaging, but it's not the case. So that's important to also remember one thing of GI. It is registered normally for a type of products, not a class of products. If you are familiar with trademark, you know that you have to protect your trademark in the different classes, but there is no classes in GI. There is different classification, which are generally fixed nationally or regionally in the case of EU, but not based on an international classification of trademark. And it will also allow sometimes for the protection to exceed the category of products under the GI, which the GI is produced. For example, wine. You will be able to protect this name for the misuse of this name in other category of products. That's also a particularity of the enforcement of the GI system. You have also evocation. So you told me what is evocation. You may know the GI from France, cognac, and you can find here some packaging and some brand which are using not identical name, but name that could be either written similarly or having a phonetic spelling similar, or actually trying to create some doubt in the mind of the consumer. Now, if you have a cognac, for example, or cognac, that could be pronounced similarly, but write differently. So what you can find in the market is people trying to use something not identical, but as an evocation of the name protected under the GI. And in some jurisdiction, that could be protected as well. So when we talk about external infringement, if I try to summarize most of the time what are the provisions in legislation, they protect, for example, against the designation or presentation of good by any means, which may indicate or suggest that the good originates in the geographical area other than the true place of origin in a manner to mislead the public as to the geographical origin of the good. It should also protect against the use of a registered GI for direct or indirect commercial use in respect of goods that are identical or comparable to those of the registered GI where the misuse benefits or would benefit from the reputation of the GI. It will also protect normally against the use of registered GI for direct or indirect misuse. Actually, it's the same provision. The use of registered GI identifying products not complying with the specification or not originating in the place indicated by the GI in question, even when the true origin of the good is indicated on the GI, or the GI is used in translation or accompanied by expressions such as kind, type, style, imitation, method, or the like, including imitation, evocation, and translation of the registered GI. It should also protect against any people engaging in a conduct which constitutes an act of unfair competition, being an act of competition contrary to honest practices in industrial or commercial matter, including acts such as to create confusion by any means, whatever with the establishment, the goods, or the industrial and commercial activity as a competitor, false allegation on a course of trade of such a nature as to discredit the establishment, the good, or the industrial and commercial activity of a competitor, indication or allegation of the use of which in the course of trade is liable to mislead the public as the nature, the manufacturing process, the characteristics, the suitability for their purpose and the quality of the good. And a person who contravene to these subsections that we saw on GI rights is guilty on an offense and is liable to summary conviction, to a fine not exceeding a certain amount fixed by the country, or even sometimes to imprisonment or both to protect his right. Each country fixing these penalties and sanctions that should apply to the use of GI. They are sometimes very different from one country to another. There is also should be in the legislation specific provision concerning the implementation of such offense, and it should be determined by specific regulation for the potential infringer to be aware of the risk they're taking on infringing the law. And it's very important also because we see that as a very important tool to fight against the misuse of GI. Provision should also include the protection of GI as an ingredient, as well as the use of GI in the internet, including the use of domain name. That is something sometimes which is missing in the legislation. So if people are not claiming, for example, they are using the GI entirely, but they think they can use the name of a GI in a packaging as an ingredient, there is sometimes a void here, and the right holder don't know how to protect themselves, and the infringer are going for this kind of advertisement because they think they are protected. In terms of remedies, what we may face also is different type of remedies available in country. We can have civil remedies. I will not go into details. We can have administrative remedies. And we have also criminal penalty as well that could go to a detention of the goods, a confiscation of the good, sanction penalty given to legal entity or to individual entities. What is important, and I try to summarize here, is as a matter of strategy, when we want to design enforcement, we may have 3 different levels of intervention, and it's interesting to keep that in mind because it will have an impact of trying to optimize the cost of enforcement for the right holders to protect the GI in relevant market. The first level is, of course, individual stakeholder. As an individual producer, as a brand, you may be able, if you have sufficient resource, to file a complaint, to file a prosecution against an infringer. That could be done by any individuals, whatever they are, from the producer group, or sometimes even a consumer can file a complaint. Then you have a second level of action that could be a collective action. That could be to the GI association, for example. So the GI association will be the one, actually, because they may hire lawyers, they may have some fund available for that will defend the GIs as a group, as a right. And the last level, but sometimes also the most efficient, will be external action, ex officio action. The authority, for different reasons, will take over. They will also protect the GIs on behalf of themselves as a country originating where the GI is originating from, but also as a support of their producer, because there may be some awareness that the producer may not have sufficient resource to protect themselves, especially in foreign market. And that's the next step, where your GI will be infringed. National market, that's normally the easy way to be protected, because you can have some coordination between a producer, between authority, to be sure the situation is clarified. In international market, that may be more complicated, because it's involved different procedures, different laws, different costs, and different language as well. So, for example, I was mentioning yesterday that governments are putting in place national GI label for the promotion of their national products. But the fact, like in many of the legislation, this label become compulsory, it gives an additional tool for you as a producer to trigger the reaction of the state to help you to protect your GI. Why? Because this logo will be on a packaging. So often, when people will try to misuse the GI and perhaps copy some packaging, they will try also to use this logo, which will be a big problem, because the government will definitively want to protect this logo because it belongs to them. They don't own the GI individually, but they will own the use of this logo because it will be a national logo. So you can have some strategy also developed by the government to protect GIs in foreign market. So to summarize, what I would like to emphasize here as a producers, as a state authorities, there is different steps to guarantee that your products will be better enforced. First, when you design your specification and when you put in place your national control system, as well as each GI internal control system, it is very important to be very clear, to have the right information, because that will ease later on the enforcement of the GI. It will be also very important to be active in a protection against usurpation, not only pure copy, but also some different form of usurpation. It will be important to maintain the reputation of your products. So, for example, if somebody infringe your right and infringe a GI, and there is some issue, for example, health issue, it will be very important to have some communication to explain to the public that it is not the GI itself which was a problem, but it was this operator which was not producing GIs that eventually delivered these sub-quality products. And of course, anti-counterfeiting activity has to be put in place to maintain this reputation in relevant markets, national or foreign. And to do that, you have to use all the means available to you. You have to consider the cost. So, for example, GI doesn't function alone. When you're going to promote your GI in your packaging, in your labeling, you may eventually use different IPR, right? Design for packaging, industrial design for packaging, copyright if you're doing some videos, trademark if you are doing collective trademark, certification mark, or even individual mark. So all these instruments are enforceable. So it's important also to see what is the most effective legislation and the right on which you should attack the infringer first. That may not be the GI sui generis system, for example. Some countries don't recognize GI sui generis system. For example, in United States, you will have more chance to focus on the enforcement of your collective brand or your certification brand to protect your GIs than just the GI itself. And one tool that you may have to use on GIs that is not available for other intellectual property rights, it's the intervention of the state to help you to protect your right. We know that there is three main ways to register GIs from one country to another one. Is a direct application. That could be done by the producer themselves, or sometimes it's happened often. The government are helping this process by filing on behalf of producer in other markets. That's happened a lot, for example, for ASEAN GIs, which are protected in the EU. There is also the capacity for your country to join international treaty, and Alexandra, which is coming next to me, will certainly be very clear on the benefit of using such kind of treaty with the WIPO Geneva Act of the Lisbon Agreement. And you have another option, which is unique to GI, is some government can decide to have an agreement either to FTA or direct agreement to exchange GIs from their respective country, and often associated to this protection, mutual protection country, are also associated some activities that are facilitating the enforcement of the GI in the partner country. So I think I'm running out of time now, but I just put here a list of legislation that you may also consider besides the GI sui generis when you are tending to protect. Is a trademark law, where you can have this provision on the protection of certification mark, collective mark, for example. Also unfair competition law, consumer deception law, passing off. That is a type of instrument you may have to consider. Also considering, as I mentioned before, the mix of the legislation you may want to trigger when you are yourself as a producer, as a trader, when you commercialize your GI under specific packaging, under collective trademark, you can trigger several legislation in the same time. And here you understand why when you see some example of packaging, when you see here for Campot papers, the name of the GI, the national logo, the EU logo, the collective logo. So all these tools can be enforceable and triggered in a market. So finally, who are the key actors of the protection? The GI producer and the association, because they are the right holders, but also there will be support from the GI competent authority, IP office, or other authority competent for the protection of this right. The state in general, fraud department, customs, police may have the capacity to work ex officio to protect this right, and the consumers. You may have also a consumer willing to fight to protect the GIs if they find that they are endangered by the misuse of a geographical indication by improper users. Thank you.